You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. Today's episode is part of a special edition series, Groundtruth, created and produced by our partners at Beveridge and Diamond PC. We're grateful for their ongoing collaboration and partnership. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Welcome, listeners, to another episode of People, Places, Planet. I'm your host, Sebastian Duque Rios, and since today's episode is part of the Groundtruth series with our partners at Beveridge and Diamond, I'll be passing off the host baton to Hilary Jacobs and Justin Smith. Hilary's a principal at Beveridge and Diamond, and Justin is of counsel in the firm's Washington, D.C. office. They will be meeting with New Jersey Department of Environmental Protection Commissioner Shawn LaTourette for an in-depth conversation on how New Jersey is advancing environmental justice and navigating a shifting federal landscape. Environmental justice remains a rapidly evolving area of policy, and New Jersey has become one of the most active states in embedding EJ into core environmental programs, community engagement, and regulatory decision-making. Recent state actions, such as enforcement efforts led by the New Jersey Attorney General and the New Jersey Department of Environmental Protection to address long-standing contamination in overburdened communities, underscore how central states have become in delivering environmental protection on the ground. Against the backdrop of fluctuating federal priorities and funding challenges, New Jersey's experience offers a clear look at how state leadership can maintain momentum for environmental justice. Hilary and Justin, take it away.
Commissioner LaTourette, thank you for being here. To begin, could you please tell us a little bit about your organization and your work there? And I'll just note, I know we've covered this with you in past episodes, but just for the benefit of our listeners to get started.
Sure. First of all, Hilary, thank you, and thank your firm and ELI for doing this podcast. Really appreciate the opportunity to share some of the work that's going on here. We're an agency of about 3,400 environmental professionals, manage a budget of about $1.4 billion a year. And one of the things that's unique about our state environment agency is that we're one of few in the country that is a big tent or big umbrella environment agency, meaning that we are the environmental quality regulator akin to EPA on the federal level. We're also the state's Department of the Interior. We're the largest landowner in the state. We steward 1 million acres of public lands. We run our state park system and our fish and wildlife. We also function as the proactive parts of FEMA with climate resilience planning and flood controlling climate resilience infrastructure deployment. We invest yearly about $1 billion in environmental infrastructure. So it's a pretty broad umbrella here in the state. And I serve as the chief executive. And as a side gig, I teach at the Rutgers Law School on environmental topics.
And jumping into our main topic today, the Trump administration has made a lot of big changes on environmental issues. They've been abolishing programs, laying off staff, dramatically changing priorities across the federal government. Could you give your reaction to those changes?
As an environmental professional and environmental lawyer, I'm troubled by a number of them. With respect to the implementation of environmental law here in New Jersey, we have not seen much change as a function of what the federal government is pursuing, say, for example, at the US EPA. But that has to do with our unique position in that framework of cooperative federalism, where, yes, the US EPA is our co-regulator, but New Jersey has a really long, strong, proud, and bipartisan history of always being a cut above where the federal government is. We treat the federal floor as indeed a floor and one to be exceeded. An example of that would be we were the first state in the nation to enact a drinking water quality safety standard for any perfluorinated compound years before the federal government got there. So too is our work on environmental justice. And that has to do with a lot of the underlying statutory authorities and the work our legislature here in New Jersey did at sort of the dawn of the environmental movement, and things like the New Jersey Spill Act, our state Superfund. It was actually the template used to create the federal CERCLA law. And so I think as a function of that history and the way that the law functions here. We're not experiencing a backsliding. Now, there's places where we are. The most obvious of those would be in the vehicle standards arena because, well, only the feds, California, can set those standards, and New Jersey has always followed the California clean car, et cetera, regulations. So we're seeing some effects there. And of course, there are funding issues that are affecting in state environment agencies around the country. But that impact is also less here because we don't rely overwhelmingly for our environmental governance functions on the funds received from the federal government. That's not to say it has had no impact. It's just an impact that we're able to shoulder the responsibility for in their absence.
Related to these environmental justice changes, there have been changes on policy with respect to diversity, equity, and inclusion, or DEI. And the administration has treated environmental justice and DEI as part and parcel of the same phenomenon, made changes on the DEI front, tried to take actions to prevent companies and others from having DEI programs, suggested they're going to go after DEI activities and programs. Do you have any thoughts on the relationship between environmental justice and DEI and how those two things fit together from the perspective of the state of New Jersey?
I understand the actions of the federal government and that the federal government appears to be treating EJ and DEI as in some way linked or as though they were the same subject matter, but they are vastly different from one another. They are separate principles of public policy, separate principles of law, separate theories of governance, and they relate to very different things. While I understand the approach of the federal government, at least insofar as it's a point of political rhetoric, it's operationally, and as a matter of law, these things are really different. And one of the things I find interesting is in an executive order or things of that nature, we've not seen them conflated as a matter of our operations and implementation of baseline environmental laws that stem from the federal government. Those executive orders, and however they may be interpreted at the federal level, they're not affecting in a negative way our implementation of the Federal Safe Drinking Water Act, for example, or our assumption of the NIPDES program or any other program. We assume it's not having a detrimental impact and it's not negatively affecting the state's execution of our freestanding environmental laws that force multiply what we assume from the feds. That said, that's my experience in New Jersey. I wouldn't say that that is a uniform experience across the country.
Thank you, Commissioner. That's really interesting. And we can dive a little bit more into that and potential impacts later in this conversation. Before we get there, I want to step back and talk a little bit about state roles in the current climate. And as background for that, I was wondering if you could give your audience a brief summary of your state's approach to EJ, some of your state's cornerstone policies and programs for tackling EJ issues. Obviously, this includes the landmark 2020 environmental justice law. We just wanted to touch on that for a moment to set the stage.
I'm happy to dive into this discussion. Not unlike the federal government prior to January of 2025, New Jersey had had a series of environmental justice imperatives that were advanced by executive action. Not unlike the Clinton-era environmental justice executive order from 1994 that was a guiding point on advancing environmental justice ends for the last 30 years. The state of New Jersey, too, has had both executive orders that call agency attention and action to and around issues of environmental justice, and also administrative orders issued by DEP commissioners of both parties, to be clear, to advance these endpoints. And that happens in both a regulatory and a non-regulatory sense. When we talk about our 2020 EJ law, that law integrates environmental justice considerations into our, what I would call kind of core functional environmental programs, air, land, water. Whereas our environmental justice commitment is far broader than that. I'll give you just a quick example to help make that point. So I mentioned at the jump that our DEP has a broad umbrella that relates to natural resource restoration and parks and open space acquisition and improvement. Those issues too need to be examined from the perspective of how we reach and how we serve communities that need us most because they suffer from much environmental burden, or that have not historically received the same degree of support from these programs. And so we weave those considerations into things like how we fund our open space improvement programs, our urban and community forestry programs, these points that serve how we deliver net environmental benefits, as opposed to the way that many folks may see environmental justice in how we reduce additional environmental burden. So we look at this Venn diagram of both reducing environmental stressors and increasing environmental benefits.
Thank you, Commissioner. So it really sounds like environmental justice has long been deeply ingrained in everything that NJDEP does. And while we kind of point to the 2020 EJ law as this watershed moment for the country and New Jersey as well, your efforts date back well before that.
They do. And I wouldn't tell you that all of these environmental justice imperatives or commitments ingrain themselves, or that they have always been ingrained. It takes work. It's one thing to say that we're going to look at something through an environmental justice lens or through an equity lens, whatever folks may mean by that. It's one thing to say those words. It's another thing entirely to perform that work. And it takes a degree of systemic reformation and even departmental and personnel reorganization in order to advance imperatives like this. Getting folks in government to change the way they've always done something is not easy. But the worst answer you can ever give, well, at least someone like me, is that the reason we do something is because, well, that's the way we've always done it. Asking ourselves hard questions backed by data and scientific exploration, for example, analyzing how a community may be suffering from a lack of access to open space with a water quality that is safe enough, fishable, swimmable enough for them. Looking at those very specific things is really important to us, and that's what we've ingrained, as opposed to merely saying, we're going to look at something through an EJ or equity lens, because that's the value, not the work.
I think what you've just articulated really sets out your department as a role model for other agencies across the country that strive to deeply incorporate environmental justice as much as your state has. Over time, how has your office measured the success of its integration of environmental justice into everything that it does, and specific programs, which may actually be easier to track than my first question?
Yeah. First of all, it's important to track because what gets measured gets done, right? What gets measured and what helps to justify and propagate the good ends of imperatives like this. I wouldn't tell you that DEP, the New Jersey DEP, has integrated environmental justice into everything it does, because we're not there yet. We've got a lot further to go. And part of that has to do with the way that this work is intersectional. A fine example of how we measure the success or the outputs would be in the number of people communities reached by certain programs, not just in dollars invested. The Biden administration, as they pursued their Justice 40 policy, started with the dollars, and that's understandable because dollars are easy to measure and what gets measured gets done. But that's not the only thing we should be measuring, although it's important to measure. But measuring things like improvement in those baseline stressors or improvements in those particular benefits. So one example would be when we're doing natural resource restoration, are we continuing to pursue the same kinds of projects because we know what we need to do in terms of restoring wetlands or building greater flood resilience, whatever that endpoint may be? Or are we on the ground in a community asking them what they need and how we can help? That's a metric. And so we do a community engagement tour around the state. We put up a table in a community center or a faith-based organization, and we invite that community to come talk to us about anything. It's ostensibly for them to talk to us about their lived experience of their environment. But about the environment is the only thing we hear. We hear about their concerns, transportation, for example, or pollution stemming from it, which isn't something that we have direct control over, but we can connect them to another agency that does. So that degree of constituent service, this is not where one agency of government can accomplish on its own.
States have followed suit by enacting legislation similar to or inspired by your state's 2020 law, legislation that considers environmental justice. Do any of these laws that have been passed since New Jersey stand out to you as equally ambitious, or anything kind of wish your state maybe had done a little differently? Just interested in that.
There's always things I wish we have done better or differently. If you're not doing this work with the perspective that you should be seeking consistent improvement, you're probably doing it wrong. But I don't think that we yet have a developed series of outcomes and precedents from these particular legislative authorizations in the various states in order to measure that. I'll give you an example. We passed our law in 2020. It needed a regulatory framework, like all environmental laws, or most of them anyway, to be implemented. That rule was not fully adopted until 2023 because these things take time. And to date, we in New Jersey have only issued 2 decisions under those rules. And so it's going to take time in order to see how these endeavors are playing out. I can tell you that from these 2 decisions, there is a measurable improvement in the conditions in the subject community, and that those regulated entities that went through this process, they didn't go through it kicking and screaming. And I think that this is an important reflection, and particularly among, well, I'm a former private practice lawyer, and I know you all are. I think that there can be a perspective on endeavors like this where the private sector might see them as being another hoop to jump through, right? Another set of objectives and regulatory requirements to meet. I think one of the things that I'd hoped would come out of this law, we only have 2 decisions by which to make this statement, so maybe I'll end up being wrong. I think this process is providing the regulated community, who, in my opinion, by and large, is a compliant regulated community, providing them an opportunity to engage with the communities that host them and show those communities how they are being good neighbors and how they will continue to be good neighbors. And that was my hope going into the work to develop the legislation 5 years ago, or that dated back before that, 7 years ago. And I think only time will tell. Will we have some regulated entities who might balk at a condition that stems from the environmental justice law and regulations? I'm sure we will. The regulations themselves are still being appealed, and our appellate court has not yet heard that contest. But I think it's going well. But there haven't been that many applications that have even fallen subject yet to this law, which has been another lesson that I think is important, because the law itself is pretty narrow in its scope.
Those are really great points. The point of how long it takes everything to kind of trickle through. It's a really excellent point. Justin?
That is a great summary of what's going on in New Jersey. And there's a lot of, New Jersey has a really robust framework for environmental justice. I was going to bring us back to the federal landscape a little bit, because Obviously, as we talked about, what used to be a very supportive federal government, that has changed. And you touched on this a little bit earlier, but given that New Jersey has a very robust legal framework and that the federal government is leaving the field, to what extent and in what areas does that leave gaps where there may not be federal activity, environmental justice protections, or support that used to exist?
This is a great question. And this absolutely varies by state, and I think in a pretty significant way. In order to really dive into that question, Justin, we got to reflect a little bit on what it was that the Biden administration was doing. And there were two really salient things going on in the Biden administration's approach to environmental justice, of which I'm sure there have been and will continue to be many critiques. The two primary approaches that I experienced was the approach on helping to deliver net environmental benefits through some of the large pieces of legislation that were passed by Congress, the American Recovery Plan, the Bipartisan Infrastructure Law, the Inflation Reduction Act. Each of those had an environmental justice lever, and that lever grew in each of those laws, and significantly so. And a lot of the effort in the Biden EPA was around creating those grant programs and getting those investments out the door. We saw that took too long and was too cumbersome and suffered under its own weight a little bit. Now, on the flip side, as a regulatory matter, they leaned pretty heavily into Title VI of the Civil Rights Act. Less activity, at least insofar as I experienced it, but maybe other states have a different experience. Less activity was around the propositions that Hilary has been diving into here about how to integrate data-based decision-making and to advance environmental justice endpoints within the core functional programs of the EPA. I don't think they got there in any significant way in the work that was going. They were trying to do a lot of things all at the same time. And I don't think that sort of regulatory permutation had as much emphasis as the other two that I just mentioned. And so as a function of that, what do you see then at the state level? Well, you see the rolling back of that investment into environmental justice communities. Grants have been friends. Grants to the NJDEP have been voided for environmental justice endpoints, not programs. Projects have been threatened. Programs have not, but that's important. And that has been more deeply and negatively impactful in community than in government. We have many community-based organizations that have had funding pulled and or threatened in this state and around the country from the environmental justice grant making.
Is that a gap where the state has some ability to make up the difference, or obviously it's financially very burdensome to do that?
I don't think so. From a public policy perspective, what the Biden administration was trying to do in reaching community-based organizations, and it was really interesting approach to advancing environmental justice. Interesting. It was more innovative than we've seen from the federal government before, and a bit cumbersome to operationalize, as I think folks have seen. But that doesn't mean it wasn't a worthwhile thing to do. But the flip side of that is it didn't necessarily create capacity within the state environment agencies to do more work to promote environmental justice. And that strikes me as a missed opportunity as someone who is committed to seeing gaps that create environmental injustice filled. The states, by and large, I don't think can plug the holes left by, $3+ billion in environmental justice grants across the country. States cannot do that. And especially not if they are at the same time having to plug gaps in their own budgets because federal support for state environment agencies is going down. And that's probably not a coincidence.
Are there ways in which states can team up or work together on environmental justice issues? Are the states collaborating, or are there efforts to help other states stand up their programs that do need support?
Yes, that collaboration does occur. And is occurring in smaller ways that I've seen. There's a lot of knowledge sharing and, for lack of a better word, like technical assistance that states are sharing with each other as they pursue state-based policies. But these aren't large staffs, by and large, in the state environment agencies. In the EPA, on the federal level, they created this separate office of environmental justice and external civil rights. They staffed up in a big way, but that was mostly from a grant-making perspective. I probably would take a different organizational perspective to how you advance environmental justice than the prior administration did. But I'm a systems efficiency nut.
That's how you make sure the policy works. Just to follow up on the funding issues, which are critical. I don't know how much you can say about the extent to which the state's funding streams have been affected by these changes and whether all the funding that's been affected is related to EJ or has some of it been affected by funding policy changes that are nominally EJ related but has been compromised?
From a discrete EJ funding perspective, the Biden administration had both government-to-government environmental justice grants, and then it had community-based grants. Their EJ grants in the government-to-government bucket was the smallest bucket. It was not a big investment in state capacity. And by extension, you've seen states that have received an EJ government-to-government grant receiving termination letters for those grants. We received such a termination grant, and we're taking that up through the adjudicatory process to appeal it. Now, that's happened across the board, but the same is not true of the baseline grants that every state environment agency receives. By that, I mean state environment agencies implement 90% or more of the environmental laws of this country. The EPA plays a much smaller role in implementing environmental law on the ground than do the state governments. This is a point that my state secretary colleagues and I remind them most frequently. And we remind Congress as well. So that is an often underappreciated, and to my surprise sometimes in talking to staff on the Hill, an unknown fact. And so when you are appropriating and you see the line item for tribal assistance grants, that may sound to someone who doesn't really know this policy space well, like surplusage. But those are the grants that power the agencies that write the permits. You cut those, you grind business to a halt. And those grants are proposed to be cut. And that is problematic. And that should be of deep concern to every major company, every company large and small in this country, because many agencies aren't like the DEP in New Jersey, where we get more than many others. And we have authority over our fee structure. And so if STAG grants go down to the state, and they are proposed to, my only option is raise fees on business, the exact opposite outcome of what I would imagine this federal administration would want to see. It's a problem for business. Is it also a problem for advancing environmental justice? Obviously, because the best way to advance environmental justice is by modulating your underlying implementation of the core functional programs.
In other areas, the administration had actually begun filing lawsuits to challenge state programs. They have filed suit to challenge California mobile sources. They've filed suits to challenge the Vermont and New York climate superfund laws. There's some other examples. Do you think that's a possibility in the environmental justice space, that states with robust environmental justice laws will see some form of federal action, either directly or indirectly directed at businesses participating in those laws?
Not if the federal government operates in accordance with principles of cooperative federalism, which they purport to, which the whole system of environmental governance is based upon. What I imagine and have seen some signals of is, while the federal government is not supporting, for example, an environmental justice condition as being authorized by the Federal Clean Air Act, they are not contesting, in my experience, the state laws that are passed by state legislatures who were elected by representatives of that state And it's their rights and it's the state's rights that empower programs like this. I would think it's antithetical to the legal theory that you would expect this federal administration to stand for and to advance. And I also hold a lot of hope and hold our legal system and the practitioners within it in high esteem.
One last question. You've talked about this with respect to permitting and increasing costs to business, but such potentially brewing federal-state conflict on EJ, were it to pass, how do you think it could affect private companies trying to simultaneously comply with state and federal law?
From the perspective of being a former private practicing attorney who represented regulated entities, governments, community-based organizations, and the struggles that any regulated entity might face when you've got competing imperatives at the differing levels of government. I think you see that in sort of a bidirectional way. By that, I mean, under the prior administration or the Biden administration, you saw one perspective from the federal government on EJ and quite a different perspective in some states. And there was conflict, and particularly around Title VI, with states being a potential target of a Title VI investigation or inquiry at a minimum. So I think these issues are navigable. Would I envy the regulated entity or the counsel upon whom they must rely to help them navigate? I wouldn't envy them, but they'd be lucky to have such able counsel to help them navigate such competing issues. I think we try in New Jersey real hard to demonstrate that we can walk and chew gum at the same time, and we can both keep our commitments as a matter of cooperative federalism and abide our state laws, to which we are also obligated to implement.
Commissioner, thank you so much. This has been just so interesting to get your insights. And as always, we love hearing about what's going on in the great state of New Jersey. Before we wrap, does anyone have any closing thoughts they'd like to share? Justin, any closing questions?
That was really interesting. And it is good to hear that the state of New Jersey, and I think other states, are continuing with this really important mission. So we really appreciate all the work you do and your being with us today.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.